Good morning. Welcome to Member Focus Monday. I'm Christina Schaefer, Director of Social Media for HAR. And this morning we are joined by HAR's Legal Counsel, Grant Harpold. Welcome back, Grant.
Good morning. Great to be here, Christina.
Thank you for joining us this morning. We're really happy to have you. We have a lot to talk about, a lot of things going on, and definitely some things that you've noticed, especially right here on social media. So we'll get into it in just a moment. For any of our members who have not heard an update from you before, if you could just tell us a little bit about who you are and what you do.
Yeah, I'm a practicing lawyer for 35 years now, and legal counsel at HAR. I'm with the firm Buck Keenan LLP, and enjoy talking about these issues with y'all. It's a great honor and pleasure.
Absolutely. And you actually just spoke at our HR Engage conference last week. So thank you for that. We're happy to have you back here this morning to talk about even more. So thanks
Now
again.
that we had a yeah,
Yeah, go
it
ahead.
was a great conference, and we had a lot of great feedback from it. So yeah, kudos to y'all again for running a great program.
And thank you for always jumping in to speak when we need you. So let's dive into it. You've been on our program before a few times. Are there any new laws that have gone into effect since your last visit on our program, or are there any that are going into effect soon that realtors should be aware of?
Well, we spoke on this and touched on that at Engage, and we had some good feedback on it. And so I'm happy to talk about it again. And that's the disclosure that's going to be required of landlords in regards to flooding. So if you're a landlord and there was flooding at your property that you plan to rent in the last 5 years, that needs to be disclosed. Or if you're a landlord and your property that you plan to rent is in the flood zone, the 100-year flood zone, then that needs to be disclosed. And so it's a great law. It will become effective on January 1, 2022. It was a project that our own member Bill Baldwin started 4 years ago, and it finally came about this session. So he started it, tried to get it done 2 sessions ago, and finally got it done. So great job there. And it's the consumer needs it, the tenant needs it, and it's going to be something that you as a licensee will need to be aware of on the landlord side and on the tenant side. A, that your tenant gets that document, and B, if you're on the landlord side, that you provide that document, and it has to be something in writing, it has to be a separate document. TR should be coming out with a form between now and then, and so it effectively becomes law like I said, on January 1. So any lease that you enter into on or after January 1, or if you renew a lease on or after January 1, then this law applies in this form, and this disclosure applies. If you have a lease that's pending through that period, it's not a requirement, but it's something to consider that you might want to update just your tenant on those issues. Like I said, it's not required if your lease is still pending, but it's something you might want to consider to do anyway, just because we know that it's out there. And so the net, and I'm just going to keep going here, Christina.
Yeah.
The net effect of if you don't provide the disclosure, and there is damage to the tenant's property due to a flood, then the tenant can terminate the lease within 30 days of that event and surrender premises within 30, some time thereafter. And so it is something that you need to be aware of, and that is a great victory for everyone, I think.
Absolutely. And January 1, it sounds like it might be far in the future, but that's really not too far down the road, especially when you're working with these contracts, and it does take some time. So it's great that you're letting our members know about this now. That way they can inform their clients, whether they be landlords or tenants. So everyone is aware. Now, where can you said Texas Realtors has all that information, so they can find all of this on Texas Realtors website?
Yes, they've come out with information on it, and they should be coming out with a form, because it is going to require a separate writing, something separate and apart from the lease. That is that it's a standalone document, if you will, sort of like a seller disclosure notice, standalone document that the landlord will need to fill out and provide to the tenant. I have not seen the form yet. I understand that it's in the making. There is time, obviously, but just something to be aware of, and like I said, it's something that both sides needed.
Absolutely. And I'm sure we will see some emails come through from Texas Realtors once that form is ready. All right. So actually, there was a question that already came in about in regard to this. So let's go ahead and touch on this now. And if you have more questions for Grant, feel free to type those in. What about investors and flippers? It says here, they always say unknown. So what about in those scenarios?
Well, if you're a landlord and you're leasing, you're entering into a lease with a tenant, then this applies starting January 1. So I don't a flipper and an investor may or may not be a landlord, but if you are a landlord and landlord is a landlord, I mean that's not an uncommon term. If you fit that role, if you're entering into a lease for a tenant for a property, then this applies to you. So
Okay.
it's pretty straightforward.
Now, Trish had another follow-up question. What about landlords that don't use a realtor and the MLS?
Still applies. So presumably, if you have a realtor, then the realtor needs to be involved in this as far as getting it to the other side or prompting you maybe to get it done. But if there's not a realtor involved, and that's not uncommon, it still applies. This law applies to the landlord. This is the landlord's responsibility. But if there's a realtor involved, then we know that realtors assist clients like a landlord or a tenant in getting that information processed.
All right, very good. Let's talk a little bit about some headlines because we see headlines everywhere. We see them on websites, we see them on social media, but specifically real estate headlines. Are there any, legally speaking, are there any headlines going on in the industry that our members should be paying attention to? And if so, where should they be getting their information from? Where can they find more information?
Yes, I mean there's a host of things going on. You could really wear yourself out looking at it, but it's really there's lawsuits going on, and there's perhaps government investigation, and there is government investigation going on into the industry, just to under the pretense that things need to be fair for the consumer. And are things currently fair for the consumer? I mean, there are arguments that people say no, and there's people on this side that say yes. And so the issue comes about. I guess the kind of the real focus of the issue is the commissions and the offer of compensation rule that is required on a property that is listed in the MLS. So that rule that requires some sort of offer of compensation to the buyer's broker, that rule in the MLS is under scrutiny. It's under scrutiny in multiple lawsuits that are on file across the country, and it's perhaps under scrutiny by the Department of Justice just because there's a new administration and there's new people in the Department of Justice, and they're taking a look at everything, not just in the real estate industry, but in a lot of industries, in the social media industry and in various other industries. They're taking a look at how, to make sure that to some degree that the playing field is level or fair to the consumer. And so that information is pretty readable, can be found pretty easily on Google or Inman if you take Inman, or go to NAR. You can find they try to keep up with it, but the Wall Street Journal reports on it a lot. And so it's the industry just as a whole is being looked at from a regulatory standpoint, just to make sure that it's fair and a level playing field for the consumer and for other competitors. And so that's sort of what's going on. The crystal ball on what's going to happen, there is no crystal ball. I have I have no idea. I don't think anybody really knows where this is heading. There may be more pressure on how a commission is displayed or disclosed to all parties involved on the front end of a transaction. There may be a loosening of the offer of compensation rule within the MLS on submitting a property. We don't know, but there's all sorts of ideas and speculation and opinions going on out there, but it's still not clear as to what actually will occur in the future in that regard.
Okay. And we did put in the comments that members can sign up for their free Inman Select subscription, har.com/Inman Select. Every HAR member has access to that for free. And I did also want to mention that HAR's president and CEO sends out an Insights newsletter every Friday to HAR members. So check your inbox for that. If you haven't seen it, just search Bob Hale in your inbox. I'm sure you'll find the
Yeah, I mean
newsletter. It comes out every Friday.
that thing that Bob puts out, that newsletter, it's
Mm-hmm.
like it's like a report, if you will, of everything that's going on in the last week, and you have it all right there at your fingertips, and
Mm-hmm.
you can read this or read that or read it all,
Yeah.
and yeah, I mean it's very informative, and it's the easy way of cutting to the chase on what were the major headlines or the major news for that week. So
Mm-hmm.
that's an incredible tool that you now have to sort of consolidate what's going on out there and pick and choose what you want to read about or not read about.
Yes. So you mentioned the social media industry, something that I have just a little bit of interest in.
Yeah.
So what are you seeing from realtors currently on social media? And some of what you're seeing, could it get realtors into trouble?
Well, yeah. I mean, you have to be careful about what you say, and I would think in this industry where your business is based on a relationship with the consumer or with other people in the community, you would want to put your best foot forward and
Mm-hmm.
be, be engaging in topics that are, if you will, pleasurable and enjoyable, and not treat social media as a chance to be disruptive or ranting or raving about things, and not making yourself look all that good to your fellow competitors or to perhaps consumers who may be wondering about your services.
Mm-hmm.
And so, there's all sorts of pitfalls that can occur, and I kind of went into that a little bit at Engage, and I think I had a acronym that said eight for the what you should not be doing, and fortunately a member came up with a better one than I came up. There was actually another one that said tease, throw the
Mm-hmm.
tease out, dump the tease over or throw the tease out, and this one was seat down. So when you're on social media, you should not be, attempt to subvert what the existing law is out there, or and what I'm saying on that is that competition is good, and if if somebody has a commission that they are presenting in the MLS and it's not to your liking, and then that should be okay. That should not be a rant on social media directed to that person or to that entity. And this is really critical, and this I think we had this issue or question before. If you're a buyer's agent, and the commission may not be to your liking that's being presented, A, you shouldn't rant about that on social media, and B, you definitely should not, turn your client away from that property for that reason, meaning that no
Mm-hmm.
matter what the commission that may be offered, you should present that property to your buyer if it's a property that your buyer would be interested in, never mind what the commission that's being offered. And so, but you shouldn't go on social media and be subjective to the subvert the law that exists, because there are people watching, and it could get you in trouble. And and when I think said about target and attack and embarrass,
Mm-hmm.
there you do have a code of ethics, and embarrassing a competitor or a fellow member is potentially an ethic violation. And so your language and your words about how somebody conducts their business, even though you may hold an opinion, you should maybe check that opinion at the door, because if you start being embarrassing or attacking or targeting another member, then you could have an ethics violation that could be brought against you. And
Mm-hmm.
what I said earlier, overall, none of this is a good look if you're in the people business, as far as, you know, having an enjoyable or pleasurable conversation with people on social media. That should be the goal, and not what I call seats
Yeah, and
or
I think that yeah,
seats. Yeah.
yeah, that
Uh,
acronym is very helpful. And
uh,
I also just to kind of back you up here, I try to remind members that anything they post on social media, whether they delete it or not, it lives on forever. All it takes is one screenshot, and people will have that post forever. So even if you delete it, it still can be viewed. So just keep that in mind when you're posting. Now, Grant, you mentioned code of ethics, you mentioned law. So this isn't just MLS rules, right? They can get in
no.
actual legal trouble.
Right. I mean, it would be nice if your exposure was just to MLS rules, but it's not. Your exposure is to your code of ethics within NAR and about how you treat your fellow members and how you treat the public, and then also anti-competitive. I mean, if you're conducting or promoting or trying to rally people around you and your way of thinking and getting other people involved, like almost like a conspiracy, if you will, or a group boycott, if you will. I mean,
Mm-hmm.
that's anti-competitive, and like I said earlier, if you suggesting that if somebody offers a low commission to the public or to other agents that's in the public view, that you can't, say, well, I'm not going. Let's not show those properties, or let's boycott that builder. I think that was an instance in the past. I don't
Mm-hmm.
know. You can't, even if you don't use the word boycott. I mean, those are bad buzzwords. But if you talk about not doing business with this particular competitor
Mm-hmm.
because of the commission they're offering, or you're not showing their property because of the commission they're offering, that's anti-competitive. That's not healthy for you, for the consumer, for business, for anyone involved in this process. And so that's where you can get in trouble with
Mm-hmm.
the law, federal law for that matter, never mind MLS rules.
Yeah, very good. Thank you for that important reminder. I often hear you tell members not to get caught practicing law. What do you mean by that when you say that to members?
Well, I mean, it's look, I understand a member's mindset in the sense that they want to please the client, and that's a good mindset to have. But when you start stepping into legal issues, or you start writing language in the contracts that may affect the terms of the contract, then you have to be careful, and then that's where you can get in trouble. And sometimes it seems rather harmless to say this or to write this, but it can be troublesome. And I think sometimes where I've seen it can be an issue, if you will, is on an escalation clause. If I've seen that some that are pretty harmless in the sense that they're only one sentence long, and one may think, well, that's pretty well says what it says. Well, the ones I've seen are incredibly catastrophic if they actually had to be enforced or used or litigated, because they don't really say anything.
Mm.
They say something, but they don't say anything at all. So to the extent, and that's just by example, you write an escalation clause or write a sentence in the special provisions or wherever you may add it in an addendum to the contract, it needs to be done by a lawyer, because there are so many bells and whistles that can occur that you would need in relation to a true, thorough, enforceable escalation clause. And then Trek talks about that in Trek rules, but not specific. Well, they do mention escalation clauses. A direct Trek violation, by the way. So
Mm-hmm.
it's not just me speaking on it; it's Trek saying that also. And Trek generally says, if a form is there, use the form. And to the extent that you start writing things into a contract that are covered by a form, then that's a no-no also.
Mm-hmm.
And so it's just, it's be helpful to your client, and that is a help to your client if you get them with a lawyer, or suggest that they use a lawyer if they're going to add certain language to the contract, and any language that you add that would maybe change the terms of the contract or make it read something differently, then that's where you get in trouble.
Okay, very good. Great. The last time you were on our program, we talked a lot about antitrust with Alan Van Fleet. Are you still seeing this as an issue for realtors?
Yeah, I mean, well, yes, because NAR still sees it this way, and there may be some motions in the year-end get together, the convention in San Diego, about this issue about searching or not searching for properties that may have a commission that is
Mm-hmm.
not at the level that you think is fair for your services, which is a no-no. And then also to suggest that to your client that your services are free, and that you're not paying anything for your services, and that that don't worry about it, and stuff that sort of glosses over what really the relationship is in the between all the parties.
Mm-hmm.
And so I think To be honest, in our area, I don't see much of those two items going on, but that's still something to be conscious of because it is on a national level talked about a lot. And this is just the human side of people is that, they want to, I understand you want to get compensated for your services. So it's the human tendency might be if I see a property that is the client might like, but the commission is something that I don't like. Well,
Mm-hmm.
that's wrong. That's being anti-competitive. But more importantly, and more simply, I would say, I guess, is that that's a breach of your fiduciary duty. I mean, your interest as the agent for your client comes second to the interest of your client. So if that property is something that they might like or be interested in, or you want to discuss, show, do whatever. The commission issue should not matter for you because that's secondary to your client's interest.
Okay. Um, I want to bring up a topic that I know there are a lot of different opinions on, but I want to hear yours, and that is love letters. So, what are your thoughts on buyer love letters?
Well, that's an ongoing topic. I mean,
Mm-hmm.
NAR is pretty tough on that. I mean, let me look over here. NAR is, they don't want you to. They're suggesting that you not be involved at all. Don't deliver. Don't receive. Don't read. Don't do anything. Don't suggest. Don't do anything relative to a love letter. And so, if you're on the listing side, and that is going to be your position, maybe you provide that in your comments
Mm-hmm.
in your listing that, hey, we're not accepting love letters, and an offer will not be considered, or the love letter will be returned unopened, or not read, or something to that effect. But it's the tendency. The problem with love letters is that it may tend to cause either the seller or the buyer to trend towards a certain race or a certain person in our society that is being either fairly or unfairly, I would say, discriminated against.
Mm-hmm.
And so, the conduct of the content of the love letter could cause some sort of fair housing violation because it's causing the seller to sell this property to this particular person based on what the letter is saying about them, their family, their people, their religion, whatever it may be, or it's causing the seller to not sell the property because of that
Mm-hmm.
content in the love letter. And in the state of Oregon, they banned love letters,
Mm-hmm.
and so you can't even do a love letter there. And the the ultimately the issue as to whether you're going to do one or not is really between you and your broker, I would suggest. I mean, I haven't seen a case to show to you as to what went wrong in a love letter, either a legal opinion or something like that. So it's still sort of a little bit unknown as far as how one would be enforced on that and the content of it. But we know that at the best case scenario, if you're going to do one,
Mm-hmm.
it should focus on the property alone and not focus on you or the church down the street or anything about the personalities involved. It should strictly, suggest or talk about the property itself. And I think the fair housing issue is that of the white population, there's probably 75% of the white population that own a property, whereas in the black community or the Hispanic community, those numbers are down near 45%. And
Mm-hmm.
so, the government or others may suggest that this love letters perpetuates these numbers of where they are, just sort of continues on those sort of numbers that need to be more in balance. And so that's the sensitivity, and it's legitimate sensitivity.
Mm-hmm.
The property should stand on itself and not cause somebody to make a decision based on anything else but the property.
Okay. Going back to the topic we were discussing just a moment ago, Bev had a follow up question. Is there a problem making a buyer aware they will need to make up the difference if commission is less than the buyer's rep agreement indicates?
Well, you can have that. I think that's a good point, and that could be where we're heading in the future. Is that the buyer's rep agreement needs to be more explicit and more expressive about compensating the buyer's agent in the event that the selling side does not.
Mm-hmm.
And so, yes, you can have language in your buyer's rep agreement that covers that in the event that the selling side or the list side doesn't cover all of your fees, and that the buyer is going to have to cover some of that fee. That could be. And the question here is, it could be a taste of the future. Is that I mean, if you look at the buyer's rep agreement today, it's a little bit daunting. It's like 5 pages long, and sometimes people are just afraid to use it for that reason, and maybe
Mm-hmm.
for good reason. In the future, it may be more of a skinny down, if you will, document, and the main focus of that document may be what the agreement is between the buyer and the buyer's agent as to how the buyer's agent's going to get paid. And there may be language in there that allows the buyer's agent to try to get that compensation from the list side, depending on the circumstances,
Mm-hmm.
or part of it from the list side. So these are, going back to the national scene, these are all issues that are being thrown around right now, and it's unclear as to where everything's going to settle. Maybe
Mm-hmm.
maybe status quo is the future, maybe not. We don't know yet, but the buyer's agent agreement is one way to address your compensation as a buyer's agent.
Okay, so definitely keep an eye on those headlines because it
Yeah.
sounds like there'll be more updates to come. You mentioned fair housing in regard to the buyer love letters, and I'm just curious if there are any updates in regard to fair housing, and maybe even if you know, and I'm not sure if you know the answer to this, but has the number of fair housing violations that are reported, has that changed over the last year or so?
It's we know about the national cases, the one in New York, the ones that are just awful and just real and
Mm-hmm.
unfortunate. But beyond that, it's hard to see what is going on, especially locally in that regard. I mean, I can't, as I said earlier, I can't present to you a fact scenario involving love letters where the government said this, that, or the other, and I'm not aware of the government promulgating a rule on that. It's just applying, the common law or the application of the fair housing
Mm-hmm.
policy to the conduct of how we may conduct ourselves, or how you may conduct yourself, and trying to make sure that they all match up. So there's not really a case study, if you will, or a specific case that we can look at and say, well, here's how we do it, and so it's that may be coming, and there may be those under investigation right now. We just don't know. On the federal side, it's a little bit more closed, if you will. You
Mm-hmm.
can't see it as much as you would if there was a track violation, and certainly there could be a track violation also in that regard. But haven't really seen those come out yet.
Okay. Backtracking just really quick, Demetria just had a follow up about the buyer rep agreement. If a buyer did agree to pay all or a portion of my fee, what document is necessary for me to notify the title company, etc.? I asked since we are not supposed to write legal lingo.
Well, if your agreements with the buyer's reps, I mean, with your client, the buyer, so that would come directly from the buyer, and it could be handled at closing out of the proceeds, or just set up that way, or it could be handled separately.
Mm-hmm.
So it would be an issue that you would need to discuss and with the title company, because to be honest, this is not the normal, in the sense the title company may not have addressed this issue either. So it's something
Right.
that is maybe a first impression as we sort of trend that direction. So it's a conversation you need to have with the title company.
And I assume it's a conversation that'll be had more and more. um,
Right.
yeah, absolutely. So, with the massive increase in members over the last year and a half, it's actually been an increase of 8,500 members here locally. Does that pose a risk for brokers? Also, and I ask because I see this a lot on social media. What do you suggest to brokers that are bringing in new agents? And what do you suggest to realtors who might be working on the other side of a transaction with a new agent?
Well, I'll take the latter first. Patience.
There's a lot of questions there. Sorry,
Yeah,
Grant, but
that's
yeah, it
okay.
brings up a lot
I,
of issues.
it does, but they're real, and they happen every day. And
Hmm.
so if you're on some end of a transaction where the other side doesn't seem to be experienced or disengaged or whatever, that doesn't mean you lower your level to that
Mm-hmm.
level. That means you up your game. You double down on your game, on your professionalism, on your patience, on your attention, because that's where we need you. To be honest with you, if I'm the coach on that, I mean that's hey, you need to step up your play and get this other side maybe to see how you do it. Maybe be a mentor, and great. That'll be a great you know hand clap for that one. Or maybe they don't care. I mean, I don't know, but I know that on your end, you maintain your professionalism. You double down on your effort. You be more attentive. You increase everything you're doing if you're in a transaction with an agent who may be new or inexperienced or doesn't seem to have the click that you have going on. And then
Mm-hmm.
for the new agents coming in, I think brokers or even you know co-agents in your office. So this it can come from somebody else within your office, one of your co-agents or your broker. I mean, you need to spend time with these new agents. You need to
Mm-hmm.
listen to them. I mean, I talked about this at Engage. I mean, listen and communication and be concerned about how they're doing, not only professionally but in a personal sense, their health. The health and welfare that they seem to be okay, and setting forth this new business that they're into now, and that can be it can be challenging for sure. And so as a broker or as a co-agent in the office, you need to be conscious of helping this person along, listening to them, communicating with them, telling them this, that, or the other, fielding any questions. All questions are good questions. It is a time and a process, and there's a great article and where I gathered some of this from. It was called "Managing Through Crunch Time Without Burning Out Your Team." Managing through crunch time without burning out your team. It's a Harvard Business Review article, and you can Google it and find it, and it really lays out these. It's not just something for one particular industry; it's for any industry, and it has great application to the real estate industry and to brokers.
Excellent. Thank you so much. And just as a reminder, we did share the link to the HAR education website in the comments. And as a reminder, we do have a lot of classes that are free to members, not just the new member orientation, a lot of other classes that are free to members are very low cost to members. So if you're a broker onboarding those new agents, make sure to send them HAR's way for some of that education. And we did also share the link to the article that you just mentioned in the comments as well. So
Oh,
thank you for
good,
that, Grant.
great.
That's really helpful to us. Grant, thank you. You've shared a lot with us today. We've covered a lot of different topics. Is there anything else you want our members to know today?
I think the key to all of this is to remember that your business, and it's like in a lot of relationships, your business relationship, your personal relationship. Not that I'm God over everything, but I mean, you know, always remember it's about that other person. It's about your client. It's not about you. It's about servicing your client. Servicing your co-agents, reflecting good on behalf of your broker and your company. I mean, these are just basic principles that most of us have, and sometimes we don't always have a good day, and we maybe slip a little, and take time to just kind of reset it in your mind that I'm here, whether I'm on social media, whether I'm you know whatever circle I'm in, I'm here to make the client look good, to present my services in a good light, to show myself in good light, to be sensitive and to be listening and to be, thinking about all the things that are going around that you can use to make yourself better and to make your client more happy in this environment that's really challenging. And so it's okay to sort of stop and take a break and listen and check your welfare, your own health welfare, and take care of yourself, and just be conscious of doing a service that reflects good on you and on the industry in general.
Well, very good. Thank you again, Grant, for your time this morning. Our members are thanking you in the comments for this great information, and we certainly appreciate it.
You bet. I'm happy to be here. Always a pleasure. You do a great job, Christina. Thank you.
Thank you so much, Grant. So that is it for this Member Focus Monday. We will be back next Monday at 9 a.m. with HAR's Chair-elect, Jennifer Wahab. She's going to be discussing real estate scams and how to protect yourself and your clients. So we will see you next Monday at 9 a.m. Have a great week, everyone. Bye-bye.